Welcome to the sixth and final video in my series on ABA Ethics Opinion number 08451. The last point the opinion addresses is this. As a hiring lawyer or firm, how do you hire a freelancer from another jurisdiction and at the same time avoid assisting that contract lawyer in the unauthorized practice of law in your state? Well, here's what the opinion has to say about this. Quote, ordinarily, an individual who is not admitted to practice in a particular jurisdiction may work for a lawyer who is so admitted, provided that the lawyer remains responsible for the work being performed and that the individual is not held out as being a duly admitted lawyer. What this means is that when a freelancer hires out to a lawyer in a state where the freelancer is not admitted, he doesn't become a lawyer in that state. He becomes an individual who is working for a lawyer in that state. I'm admitted in New Hampshire. If I do some work for you in Oklahoma, do I become a lawyer in Oklahoma? No. You might hire me because I'm an experienced attorney. But for purposes of the work I do in Oklahoma on your client's case, I'm an individual who works for you and not for your client. This is the distinction that always must be maintained. I think it's simple enough, really, and it's easy to avoid complications. The hiring lawyer should always review everything the freelancer prepares, and the freelance lawyer should not sign anything submitted to the court or to the client. If these precautions are taken, there won't be any unauthorized practice of law.